Okay, good morning, everyone. Welcome back to the Maryland Public Service Commission's hearing on case number 9461, the Supplier Consolidated Billing hearings. We appreciate the Office of People's Counsel being with us today. Mr. Auslander, thank you. Look forward to your presentation. Good morning.
Good morning, Mr. Chairman, and good morning, Commissioners. As you know, OPC has filed comments in this matter explaining some of the concerns that we have over the way that the Supplier Consolidated Billing proposal has been raised. And I note at the outset that the reply comments that were filed by the petitioners contain some pretty strong language that I think really mischaracterizes the role my office has played in attempting as best we can to ensure that consumer protections are honored and observed. And in fact, we believe that that is a very pro-supply market position to take. So the comments like OPC has opposed virtually every effort to expand retail energy choice and develop competitive retail energy markets is something I would personally disagree with. I'd also note that the request for leave mentioned as grounds for the Commission accepting these late filed comments that the parties had mischaracterized the petitioner's arguments, but in fact, their reply comments themselves mischaracterize OPC's position. They note that OPC appears to argue that supplier consolidated billing is illegal in Maryland, regardless of the elements of the SCB program, which, if you review our comments, you'll see is clearly not the case. We acknowledge the existence of not only the statutory authority, but indeed the statutory mandate that competitive billing be offered. Now, at first blush, maybe that might not necessarily include supplier consolidated billing, but if you go back and you look at the Commission's previous rulings, it's clear, at least to our office, that supplier consolidated billing is contemplated to fall within the competitive billing that the Electric Choice Act specifically requires. What OPC's position really is, and what's reflected in our comments, is that we have some issues about whether particular aspects of what the petitioners have proposed would be legal, and we pointed out a few examples. The suggestion that suppliers could offer bundled rates or flat rate products that don't reveal the individual cost components. To the extent that that is what they meant. I mean, one of the problems, and rightfully raised by some of the utilities yesterday, is that the proposal as filed is really a very bare bones sort of high level concept, and with that being the case, OPC is certainly concerned about some of the remarks that the petitioners made yesterday along the lines of what they're requesting from the Commission is a order that would direct a work group to address implementation rather than policy. And if there was a detailed proposal that the other stakeholders could have responded to, that would have been one thing. But there were really with very few exceptions, a request for supplier consolidated billing, and then sort of a wish list of how they would like to see supplier consolidated billing proceed. But the problem with that approach is that at this point there's no consensus on whether those elements that are on the petitioner's wish list are in the public interest, or indeed would be legal, or consistent with existing law. We in particular have concerns with the notion that the supplier consolidated biller could direct a utility to terminate service for a customer. Without I guess in a work group setting we would hear the petitioners out, but it strikes us as inconsistent with previous commission decisions that expressly ruled that utilities would retain the sole authority to terminate service, and they would only do so for utility charges. And in fact, that sort of underlies the sort of legal fiction of supplier charges becoming utility charges through purchase of receivables, and could lead to a situation where a customer is ultimately getting terminated for non-payment of supplier charges, but they're supplier charges that the utility has purchased, so they're technically utility charges at that point. One thing that we pointed out in our comments is that the remedy of terminating an essential utility service is an extraordinary remedy. It's in our opinion, perhaps even more serious than evictions or automobile repossessions, where there are a number of rules, and those are sort of special rights that are granted to particular parties for reasons that are very dissimilar to what the suppliers are ultimately going to be offering. The remarks yesterday, analogized supply products to shopping for appliances or products at a big box store. They've made remarks that they could innovate and provide offerings similar to cell phone service plans or cable service plans. All of those products are very different than the ability of a household in the state to receive reliable electric service or reliable natural gas service for heating purposes, for keeping food cold, keeping the lights on. The idea that a supplier would just direct a utility to terminate a customer's right to that essential service strikes us as very problematic and something that the Commission should very carefully consider.
Just can I ask a question on that? What did you read into the application or the petition that leads you to just to direct? The way I read it, they would direct in the circumstance they weren't getting paid. Isn't that the same that would occur on the utility side? Isn't non-payment for service a reason to disconnect for the utilities?
It is, and I would point out a number of differences. One is that the utility is in a position of what they have rights and they have obligations, and among their obligations are an obligation to serve. They have an obligation to procure energy supply and act as the provider of last resort. They don't have a choice in that matter. The utility termination mechanism is ultimately, I suppose, buttressed on the idea that if customers don't pay their bills, then the ability of the utility to continue to provide service to ratepayers in general could be imperiled. So it is similar to some of the other extraordinary remedies that I mentioned earlier that are granted in very special circumstances, whereas in the vast majority of commercial interactions, you're really talking about contract damage. You're talking about money is the way we remedy a non-performance of one party with the terms of a contract. I'd also mention that the utilities are required to follow a number of steps before they ultimately terminate a customer service, and I suppose you could you could require a supplier consolidated biller to provide some of those services, but as BG&E mentioned yesterday, it's unclear at this point whether would they be going and making a a visit to a premise, that was scheduled to be terminated, would they be knocking on the door? Would the supplier be submitting an affidavit? I think that when when it comes down to it, the commission has a much higher level of oversight authority, and the ability to control utility behavior when it comes to service terminations, which has exercised on a number of different occasions. And we would be worried that that same level of oversight and control would not exist for a supplier consolidated biller.
And you don't think that would get worked out in a work group process? It almost sounds like you're complaining because you really wanted a very detailed petition that included, again, getting into the weeds on the dunning process and specifics as to who's going to put the door hanger on, that type of thing. I mean, can't the fact that they said that they want to have a process that is compliant with all existing regulations, and then to work out the details in a work group, I mean, are you getting a little ahead of yourself at this point in your complaints on these details?
Well, I mentioned earlier that OPC would certainly be willing to hear the petitioners out, and that was particularly in light of the lack of detail. Having said that, I would find it hard to imagine a scenario where OPC would be comfortable with a supplier directing a utility to terminate a customer service, and I think that is part and parcel of the fact that a utility has an obligation to provide the service and must exist for supplier consolidated billing to even exist, and certainly for ratepayers in general to receive reliable access to utility service.
So, are you saying that if the commission were to decide that every single one of the existing requirements for service disconnection remain in place, and the suppliers are going to do all of it, go out and hang a door hanger, do the whole 9 yards, are you saying that OPC still wouldn't be comfortable with such a provision? I mean, I guess I'm having a hard time understanding what the difference would be if the supplier did follow the exact same processes that the utility currently follows.
Well, I would be I have some doubts that the suppliers would be in a position to provide the level of protections that the utility currently provides. In my interactions with, in particular, BG&E, it's quite a process that they follow when they're terminating somebody's service. There's a lot of employees involved. It is not a decision that is made in an instance and then carried out. But if hypothetically, if a supplier was in a position to hang the required notices to knock on the door and submit affidavits, ultimately you would still come down to a situation where the utility itself is going to have to carry out the actual termination, and I guess there could be concerns that a last minute payment might currently avert a termination if the utility is receiving the payment and in contact with their crews, when they're out in the field to actually affect the disconnection, and that relationship would not necessarily exist with a supplier consolidated biller.
Well, how about if the commission were to determine that suppliers did not have the right to disconnect, but that if there was a failure to pay then the customer might revert back to SOS, for example, and certainly the supplier charges wouldn't transfer back, and potentially even the distribution charges might not transfer back. Is that a provision that OPC might be comfortable with?
It's something that I would certainly have to bring to the People's Council and get some authority. But I think I have brought up the topic of supplier direct determinations, but I think a lot of these proposals are sort of connected, and for example, to the extent that a supplier consolidated biller would not have the authority to direct a utility to terminate service, perhaps the requirements that a supplier consolidated biller have 5 years experience and 25,000 customers might be less important, because the potential repercussions could perhaps be less. Certainly, to the extent that the commission was open to this idea, OPC would strongly urge that it allow the work group to discuss these issues. And I'll point out that it is often the case, especially in supplier matters, that consensus is hard to reach, but it's not universally so. The changes to the regulations that occurred as part of RM 54, started with stakeholders with very strong beliefs and opinions on how the law should be shaped, and through a series of work group meetings over weeks and months, by and large, consensus was reached on a number of issues, and that certainly led to a product that might not have been everybody's first choice, but it was something that the stakeholders, by and large, could live with. And I think that is the benefit of a work group setting, is that we're not making very important decisions and becoming path dependent based on 2 rounds of reply comments, but we're essentially opening up the floor for discussion that began many years ago and then stopped after the implementation of utility consolidated billing with purchase of receivables. So I can understand that the petitioners would like to see supplier consolidated billing implemented as quickly as possible, but I'd point out that they've had this option for 8-9 years now, and they could have come in at any point before now and filed this petition. So, and because of the complexity of the issues and the various moving parts, we've urged caution, and while we certainly would not object to the commission offering some guidance to the work group, we would prefer if the guidance was such that there was ample negotiating space and the ability for the stakeholders to discuss and perhaps come to a consensus that at this point seems to be quite elusive. In response to some of the particular remarks that were made yesterday, we have some questions about the idea that there would be some type of economic development incentive. Not that we are against economic development in the state, far from it, but we're just unsure as to what what that would mean precisely. I know that the idea was perhaps requiring a supplier consolidated biller to have a office in Maryland, but would that be an office that would be carrying out the billing function, or simply somebody behind a desk performing a completely unrelated function? Or would that mean an office that really is a marketing or a sales arm and really has nothing to do with the underlying billing functions that the commission would rightfully be concerned about in the context of authorizing supplier consolidated billing? And finally, I'd like to share the concerns that were raised yesterday regarding the cost recovery issues. The estimates that BG&E and PHI mentioned yesterday, while I understand that that there might be some difficulty in pinning down exactly how much it will cost to implement something that they don't really know exactly, what exactly it will entail. But $4.5 million, per for BG&E, PHI, and presumably somewhere in that neighborhood for Potomac Edison, is a significant amount of money, and it will certainly affect rates. And to the extent that it's going to be borne by ratepayers in general, OPC would have some grave concerns considering the number of measures that have been implemented over the years and been paid for by ratepayers. And it seems, in some sense, that some parties view Maryland ratepayers as a piggy bank, or the source of funds to further their narrow interests, and aren't necessarily going to benefit ratepayers as a whole. The process that the Commission has typically followed in these sorts of situations is to give the work group a pretty wide latitude in attempting to reach consensus and come up with a proposal that, if it's not 100% consensus, has some underlying framework that will allow the Commission to make the ultimate decision on whether to adopt a particular proposal versus another, much easier than it would be if the Commission was in a position of dictating very narrow parameters that the work group would have to follow. So with that, I'm
I'm sorry, may I?
Yeah.
Okay. Thank you, Mr. Chairman. Just on the cost recovery issue, I'd like to just understand the OPC's position. Now, this, would you agree, is a policy that's been mandated by the legislature? Is that correct? Competition and choice is mandated by the legislature.
and specifically competitive billing.
And it is exactly part of the competitive billing. And we did talk a little bit to the utilities yesterday, and it sounds like at this point, really none of the billing systems, none of the major cost drivers have really been addressed yet to implement this policy. So generally, when we're looking at state policies, aren't we looking for then maybe a universal way of trying to at least implement them, get them started, doing what's necessary? Wouldn't that be generally the way we would approach a state policy such as this?
I think that that's certainly the approach that always seems to be followed, and I don't know that it is necessarily inherent in the underlying legislation that ratepayers would always be, the entity that would be paying for this additional functionality. In the past, we have suggested perhaps some type of cost sharing at the very least. But I think that at this point, it seems as if nearly every work group proceeding or pilot program or initiative ends up costing enormous amounts of money, and it almost always is borne entirely by ratepayers. And so I think our position would be that that shouldn't invariably be the case, particularly in a situation such as this, where there are going to be entities that are going to benefit much more than ratepayers as a whole. And we would certainly think it appropriate for the work group to consider alternative avenues of cost recovery, rather than simply look to ratepayers to cover 100% of those costs.
Okay, so I think that clarified. So you're not absolutely opposed to, again, if there are implementation costs to getting this program up and running, that some of those might be universally, I guess, shared, and then you would just leave it to the work group to decide, maybe what other kind of cost allocation. I guess what I would be concerned about is not to thwart the will of our state policies of the legislature by killing this thing in the cradle by saddling it with enormous cost to get it up and running. You're right; it is a for-profit entity, so it does need to stand on its own. But again, I just wanted to find out, from your standpoint, what is that appropriate?
Yeah, I mean, as I said, I think it's certainly an appropriate topic for the work group to consider. And I'll also mention that there are some aspects to this cost recovery issue that I think Commissioner Herman brought up yesterday, which is to the extent that the supplier consolidated billing mechanism that is ultimately adopted is not along the lines of what these petitioners, for example, had in mind, and hypothetical scenario where there just might not be a whole lot of supplier consolidated billing taking place in a given service territory. I think that should be something that the commission should consider, because from the remarks that the utilities made yesterday, these are sort of upfront costs that are sunk costs once they're paid, and it certainly would not be a wise use of ratepayers' resources to incur these costs if supplier consolidated billing is going to end up not being utilized very heavily in a given service territory.
But you would agree that we'd look to the legislature and whatever's in the statute to guide that. So in the instance, they did clearly state that for co-ops, that may not be an appropriate investment. But there's nowhere else does it say we should limit how we implement the policy, at least in the statute that the legislature passed.
Yeah, I'll agree that it does not limit. It doesn't speak to cost recovery specifically. It does not say that ratepayers should pay for the cost of competitive billing, but it doesn't say that they shouldn't either.
Okay. All right. Thank you.
Let me follow up, Mr. Auslander. So on that line of questioning, so at the beginning of your presentation, you mentioned that the General Assembly authorized competitive billing through 511, and that, in your view, that does contemplate supplier consolidated billing. So is the Commission, in your view, is the Commission in a position now with all the filings we have, and we're keeping the record open for another couple of weeks, are we in a position to determine whether or not supplier consolidated billing should go forward at this time, if the time is right for that, and then create a work group to look at hashing out the details? Or do you think that we need a work group to even make a decision as to whether or not the time is right to go forward?
Well, I mean, to the extent that the work group is going to build, for example, on some of the work that previous work groups that the Commission has ordered, I think that the likelihood of the Commission receiving a set of proposed COMAR provisions that the Commission would feel is in the public's interest, then I think that that could certainly be the result. I think that it's also possible, though, that what comes to the what is brought to the Commission might have have particular issues. It might be that the direction that the Commission is comfortable going is not shared by large numbers of supplier stakeholders, for example. And so I think when depending on how this cost recovery issue is resolved, I think that could give the Commission pause. I will say that although the Commission is directed to implement competitive billing, I think that the animating purpose of the Electric Choice Act is what the Commission should really focus on, and should clearly not take any action that it felt was not in the public interest. Not that the Commission would ever do so. But.
No, it sounds like part of your advice to us is that you would caution the Commission to go down a stakeholder process that 18 months from now we get a product that we say, well, we can't live with that, or the supplier say, well, that's what you approved, we're not going to implement SCB, that we at least make sure there are some decisions made along the way on some of these threshold issues like cost recovery and termination of service to know it's worth everyone's while to continue to proceed?
Well, I would hope that the process could be completed in shorter than 18 months. And I think.
Well, the petitioners gave us their process goes till June 30th, 2019, and that's before the delay we've had with filing. So
I understood the 18 months to be when the work group might be expected to bring a report or some type of proposed regulation. I think that could happen much shorter. I would hope.
Last time we had a stellar work group leader for RM54. We may not have that this time.
That's true. But I think part of that will, of course, be how willing the parties are to empathize with the other stakeholders and see where they're coming from and make a concerted effort to address those concerns as best they can, which is frankly what happened by and large in RM54, and it could certainly happen in this proceeding as well. Notwithstanding the fact that there are some major policy differences reflected at this stage in the comments filed.
Thank you. Anything else for Mr. Auslander? Thank you very much.
Thank you.
Appreciate your comment.
Thanks.
Next up, and last on our list of presenters is Commission staff.
Good morning, Mr. Chairman, Commissioners, Annette Garofalo on behalf of Commission staff. With me today are Philip Vanderhayden, Director of the Commission's Electricity Division, and Jason Cross, Assistant Director of the Commission's Telecommunications, Gas, and Water Division. I'd like to briefly address 3 items today. Staff has given some detail in its comments, but today I'd like to just address whether supplier consolidated billing should be implemented, what methodology should be used to address issues in sorting out supplier consolidated billing, and the policy advice that would be required should you mandate supplier consolidated billing. Staff does support the addition of supplier consolidated billing as a billing method that should be available to retail gas and electricity suppliers, in addition to dual billing and utility consolidated billing. As discussed in staff's comments, competitive billing has been used interchangeably with supplier consolidated billing, and although competitive billing has not been expressly defined, it seems that it was anticipated by the statute for both gas and electricity, and was discussed in working groups during the early days of restructuring and the passage of the Gas Competition Act. So if you decide that supplier consolidated billing is the same as competitive billing, then this would be appropriate and consistent with those previous decisions and discussions, and it would solve the problem that stems from those early times, which resulted in supplier consolidated billing not being expressly adopted.
Ms. Garofalo, are you saying that these terms are interchangeable, or are you saying that supplier consolidated billing is a competitive billing practice, not the only competitive billing practice?
The statute does not define competitive billing. and it does not use supplier consolidated billing as anything that's contained in the statute. So early decisions, I believe it's a footnote in a order regarding a working group report, does state that supplier consolidated billing and competitive billing are used interchangeably. Is out there, but I think that you could decide that what is meant by the statute with regard to competitive billing.
Well, isn't it possible that a third party could come in and say, I want to do billing? Wouldn't that be a competitive bill?
It would, I think,
Right.
yes.
Okay, thanks.
So with regard to the petition before you, staff does believe that the time is ripe, should you agree, for development of a supplier consolidated billing model, and the necessary framework for that. Now, the petitioners have offered a detailed proposal. Staff believes they've highlighted many major elements to be considered relative to supplier consolidated billing. However, staff believes that many issues attendant upon the development of supplier consolidated billing are issues best handled through a collaborative process with Commission guidance as needed. The working group process is more likely to develop full solutions to the many issues, not all of which could be addressed in the petition, attendant to supplier consolidated billing. And the working group process would take longer than anticipated by petitioners, perhaps not as long as envisioned by the utilities, but we don't know before we understand what they would need to do for implementation. For this reason, staff did not submit a specific schedule with its comments, but suggests a full work group initial report for the Commission to consider. This report would be held after, it would be submitted to you after an initial work group meeting, perhaps two of a single work group, where the actual issues to be decided would be laid out, and also with hope the dates on which this group would meet. And this has been done before, and with regard to another work group, and it did work well.
So, Ms. Garofalo, just to follow up on that point, so you were suggesting that the Commission have established an initial work group that would set out the parameters for the decisions to be made going forward, present that to the Commission, and then the Commission would go forward with a more extended process that would reach all of the issues that need to be decided.
Yes, a more extended process, but the same work group. So it wouldn't be there'd be an initial work group, and then there'd be a secondary work group or multiple work groups. But because these things are are going to interact quite a bit, I think that really a single work group would be the way to make sure that we don't get to the end and have things that don't really go together as part of the decision-making process.
So you would see one work group operating on all issues as opposed to 5 work groups working on different parts of this?
I would
Okay.
suggest that.
Okay.
Now, should the Commission decide to order supplier consolidated billing to be implemented and to send the matter to a work group, we would ask for a decision on a single policy issue, assuming that whether supplier consolidated billing is included in the definition of competitive billing services. And that is whether a supplier can terminate customers for non-payment. And staff requests guidance on the issue of supplier termination of service for non-payment, because would be a big break in the supplier experience to date. And it also would likely add significantly to the costs of implementation. Staff suggests that under supplier consolidated billing, should non-payment become an issue, the retail supplier be allowed to return his supplier consolidated billing customer back to SOS or sales service, where no money would be owed to the utility, and the supplier could collect any amount due through usual commercial channels. Specifically, retail suppliers could continue to bill those customers, seek redress in court, or sell their receivable to a non-utility collector. Under this methodology, utilities would continue to terminate for utility service only, rather than paying for termination costs associated with supplier services. And we're available for any questions you might have on this or other issues related to this.
Yeah, I'd like just to follow up on the question, just on the work group process, and I guess we've heard two at this point options. One would be a pre-work group or a pre-discussion work group, and then that would come back to us for letting this commission know whether you're on the right track or not. Or option two would be just we order supplier consolidated billing, and you with the expectation you're going to produce a set of regulations. Is that what the two options are, suggestions are on the table?
Well, the suggestion of the submission to you is really for your convenience. We could do it either way.
Okay.
And if you were to order a single work group to handle this within the context of this case, then we would probably do this work anyway. The sorting out of what to address and in what order. We would probably handle also the method of who would meet and when and how.
I was going to ask then, would there be another way to do this? Maybe would be provide some efficiency and maybe make it a little more timely, perhaps if the commission were to order that we'd like to see regulation on supplier consolidated billing, and perhaps it could be a two-part process where all the consensus items could be worked out, and then we could be notified of what the non-consensus item are with options, and then that would send us, then we could provide direction on that part. Would that be another potential way to move forward, and do you think that would be an efficient way to try to get this done in a timely fashion?
Well, I would suggest something that might be like that and might turn out to be the result of this work group anyway, and that is the majority of the work group would develop a set of cohesive regulations, but we would highlight for you those things which are non-consensus. And by non-consensus, I don't mean those things which are not every person in the room agrees to, but those things which are of great consequence to the parties involved.
Okay.
So.
Okay, good. Yeah, I was a little concerned on the first option or the first recommendation that there would not be enough, I guess, direction or focus, and that there could be just a whole bunch of meetings where we don't get any actual options on the table for regulations.
The first one being where we submit
we have this pre-work
to you?
this pre-work group option.
Well, that would be your decision, but we're attempting to show you to add a little transparency to the work group process by showing you what elements we might decide. For example, who should what we wouldn't do what is supplier consolidated billing first. We might go back to that, but or you would tell us that in an order. But who would be eligible to do supplier consolidated billing? That might be one set, and that might be one group of meetings. How would
there's some parallels with this proposal, with the development of retail choice in itself, and with POR when it was developed. So the folks who, some of whom were around at the time, recall there was a series of policy working groups that addressed very specific types of policies that involved what role suppliers would play, what responsibilities would remain with the utility, and those were addressed somewhat at a high level policy, and then there was a series of implementation working groups that took that direction. This is probably a less broad undertaking, although I wouldn't underestimate the amount of time and effort it's going to take to nail down all of the details. So I think what you're suggesting is, are there policies that perhaps would benefit from some discussion amongst the parties? We've mentioned that cost recovery is an issue. We've heard the retail suppliers say, well, we don't think we should pay for anything. And that might be a reasonable approach given what they've cited in the law. However, when we rolled out POR, those similar arguments popped up, and there was a lot of discussion as to who should pay for what. We ultimately developed a reasonable cost through the POR discount rate. There have been a number of suggestions that it's going to cost on the order of $4.5 million. That, by my calculation and reviewing some of the costs that we had from 2009 when we developed POR, that would imply something on the order of 20 or 40,000 hours of programming time, given the typical cost of a programmer that I got from the BLS website. The filings made in POR by both BG&E and PEPCO indicated about 12,000 hours at the time. I don't know if things have changed that radically, but both companies have introduced new billing systems since then. Hopefully those are more modern and wouldn't be so expensive. There may be a number of assumptions we need to dig into to understand whether or not those costs would be very high. So, and I can talk a little bit more about that if you'd like, but working out who pays for what, working out whether or not a supplier may terminate, those are very solid issues that need to be worked out. If you send that sort of thing to a working group to decide, it may be very difficult for parties to break away from their positions unless there's a direction from the Commission to say, we want you to go work out how to do this. So I've always said that when we have working groups, it's not necessarily the what, it's the how that you want that working group to work on.
Thank you.
Why don't we go first to Commissioner Herman, then Commissioner Sardone.
If the supplier doesn't have the ability to direct disconnection for non-payment, does that potentially take away the incentive to do any significant vetting of customers? Because we can send them back to the utility whenever we want, or I guess maybe would you imagine that there would be rules for when they could send them back to the utility, and how do we monitor that and that sort of thing? Because you don't want to end up in the situation where you're sending back all of the customers with payment challenge customers and then putting all of those costs on the utility, while allowing it's the whole cherry picking argument.
This
we heard
argument
that before
happened in POR, yes.
Yeah.
So I think that if you give us policy guidance of the type we suggest, but it would incent the suppliers who actually do supplier consolidated billing, and that's not all suppliers. Not all suppliers want to do this, particularly in light of utility consolidated billing. They would look at their customers' credit history more carefully, and to the extent they do that, those customers would be more likely to remain with the utility. But those customers would not be deprived of suppliers if they wanted one. And it would, in effect, lower the cost of supplier consolidated billing, at least initially, because there's a great deal of work that would need to be done to allow to make the determination by the supplier work by the utility. And so we just think that this would ease the path to supplier consolidated billing as proposed by petitioners, but it would not take away any incentive, and we don't know. Yeah, I'd like to answer your question about what would happen eventually, but we would have to know how many people are actually going to take part in supplier consolidated billing, not only suppliers but customers, in order to answer your question about does the utility still wind up with the bad apples, and does everyone else go to a supplier?
Well, the suppliers, the petitioners, suggest that they absolutely have to have the ability to order a disconnection because that's the way to get people to pay. And if do you have any concerns that if the commission provides that direction, that there won't be any suppliers coming to town, and we end up in the situation of developing a process and spending money on that process that nobody wants to come and participate in?
Your Honor, I think history shows us what happened before POR, in that at that time there was a payment posting schedule. So if a customer was signed up with a supplier and they paid their utility but only paid a portion of it, the supplier would be left hanging because their current rates were, or their current bill was behind that of the utilities. And I think that the example, the one POR was initiated, the concerns about relieving that ability to pay, and the concerns about that resulted in moving from basically about 10 retail suppliers registered to the 50 or 60 that are available now. And I'm just looking at the BG&E data from a recent report. So I think it's known that suppliers examine the risks that they have when they're offering services, and they will be attracted to areas where they have lower risk, and they can make a better business.
And has there been a significant increase in the number of customers shopping since POR was implemented than prior to POR?
Yes, prior to POR there was 5% of customers shopping. I think it was roughly about less than 100,000 customers. I think in 2009, in December, I pulled out 98,000 customers had switched, with a very small number of 7 to 11 suppliers in each service territory. Immediately after POR, it moved up significantly. I think ultimately it peaked in 2013, where we had in the mid 20%, about 26%, I think, of residential customers switched. Since then, it's declined. So our retail choice market is somewhat moving backwards. I think we're at statewide 20% switched as of the December report. So we have had a much larger number of retail suppliers that began to participate since POR was initiated, and I think it's very obvious from when you look at when POR went into effect and when the amount of switching occurred in 2010, I believe. It went from less than 100,000 to the 400 and almost 500,000 customers that are there presently, and I think the number that had switched at the peak in 2013 was probably closer to 600,000. So the POR had a tremendous impact in attracting offers and customers to retail choice.
And when was POR put in place?
2010, by my recollection. The filings that I looked through yesterday were initial filings in 2009 from each of the utilities, and I believe it took about 6 months or so to complete the implementation and ultimately the final description of tariffs. So I believe that it began effectively in 2010.
Okay, thank you.
Thank you, Mr. Chairman. I'm going to back up a little bit and make sure I understand staff's understanding, if I can. So, Title VII, Subtitle 5 implements electric industry restructuring. And as a subcomponent of that, Section 7-511 is competitive billing and metering. And that doesn't say very much.
No.
It says you'll start on this date, and large industrial customers shall begin on this date, and residential on this date. And then it says, Commission shall adopt regulations or issue orders to implement this section. Have we ever adopted those regulations?
Well, we've adopted a number of regulations, and I believe the Delmarva case came in there somewhere, so there
Specifically-
were orders at the beginning, and those orders have now been moved into regulation.
So what section of COMAR are those regulations?
For electricity, it's 2053, and for gas, it's 2059. But if your question is, have we developed regulations on utility consolidated billing, there are some regulations in there that in 2051 for electricity and 2054 for gas that would apply to utility consolidated billing, and staff relied on those in its comments with regard to DECA. They have to do with how collections should be made, and with I don't have them in front of me, but it also has to do with the financial integrity that must be shown.
So in '99, we implement electric utility restructuring. It goes into the law. And as part of that, this section, competitive billing and metering, is put into the law. And it says very little, but it says, amongst one of the things it does says, is the Commission shall adopt regulations or issue orders to implement this section. Have we had a specific rulemaking on this section?
The rulemaking that would apply to this is a portion of 2051 and 2054, and I don't know the exact date of that rulemaking, but it was very early on because it had to do with licensing.
Okay, so maybe a subcomponent of a bigger rulemaking implementing electric utility restructuring?
Correct.
Okay, just making sure I understand that. Because it's hard to ferret all that out of COMAR, because we got bits and pieces here and there. And
Right.
in light of this petition before us, I want to see how staff understands it, and hopefully impart some of your wisdom into my understanding of it, because it's not clear to me, and I'll just speak for this commissioner. That section goes on to say that competitive billers, or in this case we're calling them supplier consolidated billers, need to hold a local license where an energy tax is consumed.
Yes.
Does Montgomery County license WGL Energy Services? Do you know?
I don't know. I would have to check on that.
Later on in that section, it talks about regulations relating to assumption of billing responsibilities. And I think the way I read that is, if a local jurisdiction, and this scares me a little bit because in the code it talks about the ability of a local jurisdiction to revoke a supplier's license, but it talks about developing regulations, shall adopt regulations to issue in order to establish procedures for the assumption of billing responsibilities by the electric company. In this case, it's talking about electric company, but I guess the way I read the code here, that this applies to gas companies too, based on subtitle 6.
Although there are some differences between the electric and gas, and Mr. Cross could address those a little bit, especially with regard
General.
to terminations. Right.
It's kind of the murkiness of this section of the code for me. But it goes on to say, shall adopt regulations or issue in order to establish procedures for the assumption of billing responsibilities by the electric company that distributes electricity in the relevant service territory if a local license is revoked or suspended. Have we done that? Do you know if we've done that?
I do not believe we have, but I would need to check some ancient documents to be sure.
Okay. Would it be a fair characterization to say that this area of the code, if we're going to implement statewide policy on consolidated billing, we ought to do it consistently and at a very high level, and take a comprehensive look at all of this stuff that probably hasn't been looked at since '99?
we should, certainly.
And what, do you know what the order was that authorized WGL Energy Services to be a supplier consolidated biller?
I have that.
Can
I
you
can
get
send
that?
you a copy or send you a citation, whichever you
Very
prefer.
good. So my line of question is not to say there's murkiness here, but it's clear that there is. And we get down in the weeds on this stuff. We better be careful how we proceed is all I got to say. Would staff agree with that characterization?
I'm not sure about accepting the wording, but what I would say is that this is complicated. It brings up a number of issues. It will take a long time to sort things out. Even with this, I believe the word the chairman used yesterday, or the phrase was the soft start, which could be viewed as supplier consolidated billing without termination.
Yeah.
There are a lot of bits and pieces to be considered.
In the almost 20 years since the implementation of electric utility restructuring or utility restructuring in the state, a lot of water has gone over the dam, and it's anything but clear to this commissioner. Thank you, Mr. Chairman.
Well, we have a bridge too far and a lot of water going under over the dam. Got some good metaphors going here. Ms. Garofalo, in terms of a work group, and thanks for your input on this. I think it's been very helpful. I mean, this commission, we've had work group leaders, we've had the director of the Office of External Relations, we've had senior commission advisors lead work groups, we've had commission staff, we've had public utility law judges lead work groups. Clearly, staff is your plate is full, and it keeps getting fuller. We understand the work and the resources, that challenge you every day. Is this something that, in your view, and maybe I will have to ask Mr. Myers, but that staff could take on a prominent role in this work group process?
Well, you're correct. The final word is with Mr. Myers.
Right.
But I think that staff could, having familiarity with 2053 and 2059, staff would be well equipped to add this piece to it.
Okay, thank you. I appreciate that. Anything else for commission staff? All right, hearing none, thank you very much. We greatly appreciate your input. Okay, we wanted to make sure, commissioners, are there any questions for Mr. Green? We also have a few suppliers here. They are here, and certainly be happy to come back up if we have any questions for them. So, anything from the commission? All right, Mr. Green, would you like to make a last?
I'll be really brief. I
Brief
promise,
remarks,
but
okay.
if you can
Staff, though.
oblige for 5 minutes, I would appreciate it.
All right, we can do
press
that.
that
Let's
point.
try to stick to 5 minutes, and
All
right,
and
very
to drive that point home, I'm not going to sit down. So sitting down means
All right.
you tend to be there for a while. So just a couple of quick points about staff's comments is that there was some discussion about the costs and what would drive the cost down if there was no terminations, and I'm not sure that we would agree that that's correct. That may be something that's found out, directly from the utilities, but we do not understand what would be different in the programming and labor costs and so forth. Excuse me, if the termination issue was correct. So we didn't want to for that point to just go untouched. And then the other issue from OPC was OPC's comment that they're not, and I'm going to paraphrase because I didn't write the exact quote down, that they don't essentially trust the suppliers to handle the termination responsibilities. I was hoping someone would ask him what is the basis for that conclusion, because the testimony yesterday was that suppliers do that in supplier consolidated billing territories on a daily basis, and that they have the technology, the sophistication, and the experience in handling those functions. Again, our proposal was to leave the COMARs intact, but if the commission is more comfortable with the supplier taking on those responsibilities, we can do that. And then finally, turning to yesterday, I just wanted to highlight some of the positive things that we heard from yesterday, primarily from BGE and PHI. First of all, we really appreciate the tone and the reasonableness that PHI and BGE have received our petition since the beginning, both in their written comments and yesterday. First, we heard that they're not opposed to supplier consolidated billing, and they also said that they feel no discomfort, I believe was their word, in transferring customers to supplier consolidated billing. We thought that was pretty important to hear. We appreciated their list of issues that they developed both in their written comments and in their PowerPoint yesterday. What we took away from that was that it's a very helpful list and along the lines of the same list that we would have prepared heading into a working group. They're mostly operational and implementation type issues that if you get the right people with the right minds in the room, it can be worked out. But importantly, the people are not in the room talking policy. They're in the room talking how do we implement what the commission told us to do. We feel like that also segues into probably the one difference we have with the utilities, BG and PHI, is when should the working group start? We really feel like if we get in a room, and I think this is clear over the last day and a half, and start talking about should we have termination rights or should we not, we're going to be right back here with the same arguments and the same briefs, and you're going to have to make that decision sooner or later. The question is, when do you do it? And we think it makes all the world of sense to do it now, heading into a working group process, and the other policy directives that we had asked for as well. As an example of how this can work, we have the BG prepay program going on right now. We had a hearing. The commission issued an order as to how it wants that program to work, and now there's working groups to implement the commission's directives. So that this is happening at the commission, and it's working, and we feel like on a obviously broader scale, if you can have those same kind of guidance in this case for the basic policy directives of SCB, it'll help the working group flow, whether it's one big working group or multiple working groups or one big working group with subcommittees. However it's structured, it will be more efficient. Two more issues. One, there were some questions about the cost of the program. And, we're all using $4 or $4.5 million, I don't remember, as a bogey, right? Because that's what PECO threw out in Pennsylvania, and we don't have any information about how PECO arrived at that 4 or 4.5, and if it is even transferable here to Maryland. So I want to hope that it's useful, but there's nothing to indicate that it is. So what we do know is that the prepay program is going to cost about $1.6 million for BG to implement, but with supplier consolidated billing, suppliers can offer prepay programs, and they're doing it now in other jurisdictions. What we also know in the time of use rate design in PC 44 a week or so ago, in the working group report, the utilities each indicated that to do a TOU pilot program, it would cost about $1 to $1.2 million per utility. Those TOU programs aren't even necessary if we have supplier consolidated billing, as we learned yesterday from the executives who spoke. So finally, I just want to recognize the magnitude of the gravitas of what we saw yesterday. We had executives and decision makers from some of the biggest retail suppliers in the country representing billions of dollars of sales annually testifying here to the commission on the importance of moving the market forward. And it showed how much the market has evolved, quite frankly. I mean, we saw people referring to the year 2000, the year 2008, just now with staff in 2010. The market is remarkably different today. The players in the market from a selling standpoint are different. The technologies are different. The marketing channels are different. The consumers are different because they have different expectations of the entities from whom they buy products. We see that every day, and that came out yesterday from the panel of petitioners, but also from the other suppliers that were here. No less than 8 suppliers said that SCB will move the market forward and they want to do it here in Maryland. In addition, you had the National Energy Marketers and RISA, two of the biggest and most influential retail supplier trade associations, testifying that their members want it. So when you add all that up, it's probably suppliers that exceed 5 million supplier consolidated bills on a monthly basis, all in. So we have suppliers now that know how to do this. That didn't really exist 10, 18 years ago. And you have suppliers that want to bring that to Maryland. So that's all I have. I hope that you will, I know that you'll consider very seriously what we've proposed, and we look forward to an order. Thank you.
All right, thank you, Mr. Green. Any questions for Mr. Green? If not, thank you very much. We appreciate your comments. And again, I want to thank all of our parties over the last 2 days for not only for their presentations, but also for the opportunity to have a very robust dialogue with them. We've learned a lot in the process as well. I want to remind everyone that March 7th is the deadline. If any parties want to offer any reply comments, the Commission will be happy to receive them. And with that, I think the ball will be back in our court, and the Commission will be working on this issue, and we again thank everyone for your participation. With that, we are adjourned.